This case is being dismissed because I asked to be heard.
I do not believe that the middle finger was shown in the video.
So the video does show the middle finger is raised and the items are dropped into the trash bin. There is a prima facie case. A move to dismiss that could be deemed to be in bad faith.
Well, I believe the district attorney has a motion to dismiss, and it sounds like Mr. Ryan, on behalf of the victim, wants to make a statement, which I know they're entitled to do. So Mr. Schaefer doesn't have any objection to a motion to dismiss, and are grateful for the discretion that the DA shown on this case.
Ultimately, I do believe is the intention is to dismiss this case. So if we can just get this set over, I would say for the shortest period possible.
Mr. Powell?
That is correct, Your Honor. The people are moving to dismiss this case as we cannot prove the charge of domestic violence criminal tampering too. There are issues proving the intent piece of that, as well as the fact that it appears to the people that this case is being used by both parties in their ongoing divorce case.
Judge Kazi, I did want to object to the dismissal. I did want to ask the court not to grant it. That being said, I feel very scared being in this room and speaking in front of my abuser. So this feels like a lot, and I will refer to my notes so that I can keep on track.
Sure.
The reasons I'm feeling this way is this is an ongoing cycle of violence. This is not the first time that I have either reported or Mike has been charged. The past incidents have resulted in protection orders for me and my children and mandatory psychiatric evaluations. Mike is a manipulator. He has a history of violent and vindictive behavior. Since the most recent incident where there is a protection order in place, he has still tried to contact me multiple times, and I have tried to report it. Tried to report it to the Vail PD, the Avon PD, and the Eagle PD. There's been problems with the jurisdiction, and they're trying to figure out who they should send it to. And he's even filed a letter with this court where it starts, "Dear Cutie," and he tries to get me to dismiss this. And
Wait 1 second. So hold on. So there's something that was written to you.
The letter that starts with "Dear Cutie" that was filed with this court and sent to me via the e-filing system, despite having a protection order.
We did attempt multiple times to file police reports about that. Avon declined, Vail declined, referring us to Eagle, who did not return repeated phone calls to take a police report.
Detective Zepeda at the Avon PD said it had a clear intent to harass, but that wasn't his jurisdiction, and also said that it wasn't like I'd been punched in the face, but not to let that deter me from reporting in the future. My concerns with dismissing this are that he's going to do what he's always done. He's going to play nice. He's going to fool everyone and return to violent behaviors. I'm very scared for my personal safety and that of my children. And I'm worried that without a conviction, this is going to continue to happen again and again and again. I feel like this case is being dismissed because I asked to be heard. Mike accepted 24 months probation with DA Alicia Brisson, and that wasn't tendered when he accepted that because I had asked to be present and to be heard. The next time we met, DA Brian Powell offered him 18 months probation, and him and his lawyer declined. And now DA Powell is saying that he's not going to move forward.
I reviewed that video after the deferred judgment was offered. We did not receive that video, from what I understand, until after the deferred judgment had been offered. Upon reviewing that video, there is no way that a jury would convict on these charges. There are no raised voices. No one is swearing. Does
he say that he's going to destroy her property?
He says that he is going to put it in the trash can, in which he did. It appears that he put it in an empty plastic bin.
In this case, the allegations are that there is video footage of the defendant grabbing multiple items of clothing belonging to the alleged victim out of her closet, saying the items had been just sitting there. He walked the items down the stairs saying, "Keep filming me," and raised his middle finger to Sally. He opened the door to a small closet and said, "Into the trash it goes," and drops the items in a trash bin. He said, "You throw my stuff in the trash, I throw your stuff in the trash." Sally replied with, "Please don't put my things in the trash can." All right, Mr. Powell, is what is asserted in that affidavit inaccurate?
I do not believe that the middle finger was shown in the video. There is a motion he makes, but I don't believe it was a middle finger. Other than that, the content of the video is roughly what is in the warrantless affidavit. If the court would like, I could pull up the video and show you.
Why don't we do that?
May I approach, Your Honor?
You may. So the video does show and state exactly what is set forth within the affidavit. And the middle finger is raised and the items are dropped into the trash bin. That exactly corresponds with second-degree criminal tampering and an act of domestic violence. There is a prima facie case.
In a conversation, DA Powell also said it wasn't like I was punched in the face, and not to let that deter me from reporting. I do believe domestic violence deserves to be punished regardless of the style, and so I understand that I didn't get punched in the face, and I do not believe that that means that he shouldn't be held responsible for his actions.
I'm sorry, Your Honor, just to interrupt for a moment.
Sure.
Under Colorado Revised Statute, Section 16-5-209.
16-5-209?
Yes, Your Honor. The court may compel prosecution only if the court finds that a refusal is arbitrary and capricious. I feel that this is not arbitrary and capricious, and if I am misunderstanding that statute, please tell me. However, I do feel that that statute is directly on point here.
So this is when a judge can require you to prosecute. But is there a specific section relating to not accepting the disposition of dismissal?
I do not believe so.
All right. So here's what I'm going to do. I'm going to hold. Right now, I'm not going to grant the dismissal. But you might be right. This might be the exact provision that's on point.
I understand, Your Honor.
I read the pleading about the belief that you believe at critical stages, which this is, you don't believe that the victim has a right to be heard. Is that accurate?
That is what the Gantz case says, Your Honor, and it's good law. It hasn't been overturned, and I think basically what Gantz says is the victim absolutely has a right to be heard. It just isn't in court. It's the right to consultation and the right to be informed, and those conversations occur between the DA and the victim, and it's the DA's job to tell the court that they're VRA compliant. And they can inform the DA can tell the court that, the victim opposes it, but to allow the victim, it's not a sentencing hearing where the court needs to know that, you know, the victim's not under oath. It's not a sentencing hearing where the court is going to sentence the defendant based on, you know, the victim's experience.
So-
And
In that case, the issue was the victim may not, I guess, present a pleading opposing dismissal. That's not what happened at the last hearing was the victim has a right to be heard, and the victim states their feelings, which I have never had a circumstance where an attorney has argued that a victim must be silenced in court and doesn't have the ability to speak at a critical stage. And you are conveying that you believe that to be the state of the law under Gant specifically. And then the prosecution asked me if I would like to watch the video, which I said yes. Right before I watched the video, and Mr. Powell told me that I would not see a gesture, that would establish that intent piece. I watched the video. It was clear that the gesture existed, that Mr. Schaefer did all of the things that were asserted by the victim, all of which every single element, including intent, were established to meet the elements of the statute, both the definition of domestic violence and the definition of tampering. And it met it to a T. Then Mr. Powell told me that the reason that he wanted to dismiss a case is he thought he would have trouble at a trial. Here's what happens in domestic violence cases. They are messy. Your victims don't come perfect. But if you can establish by looking at a video the exact elements of a criminal offense, then the move to dismiss that could be deemed to be in bad faith. When you dismiss a domestic violence case, it also creates a community safety risk, which is an impact on the public. So I understand that pretty much everyone sitting here today disagrees with the ruling of the court, but sometimes the court has to make its own call. And the call that I have made is to deny the motion to dismiss. I still deny that today. Want to make it clear that, Mr. Kokeper, I do appreciate your arguments. I might be disagreeing with you today, but I find that you make well thought out arguments, and I wanted to make sure that I was making the right decision in light of all of the arguments that you made, which again are appropriate arguments. Having said all of that, I still deny the motion to dismiss. I've never had a situation where I've now disagreed with both parties and done something completely different. But here I am, and I believe my decision's correct. I'm still making that decision because I firmly believe that in domestic violence cases, there has to be a more careful scrutiny over dismissal of these cases, especially when we have a video that outlines exactly what actions with specificity meet the elements of the crime charged.
could we just get a 2-week continuance to figure out what to do next? Thank you.
July 16th